Swayam Prabha. Digital India. Educated India.
Welcome to the course on medical law. This lecture will be about intellectual property rights and access to medicine. The concepts covered in this lecture are patents and access to medicine, product patents for medicine, standardization under the TRIPS, exceptions to the patent rights, TRIPS flexibilities and the Indian approach. The keywords of this lecture are TRIPS flexibilities, product patents, compulsory licenses, parallel import, Bolar exceptions. The intellectual property rights and patents has sparked extensive discussions over access to pharmaceutical drugs. Patents can have substantial or even decisive impact over access to drugs. The patent holder's authority to choose pricing without any competition throughout the duration of the patent protection may lead to pharmaceutical drugs becoming prohibitively expensive for majority of the population, especially those who are residing in developing and least developed nations. So, patent protection grants a monopoly to the pharmaceutical company. So, this exclusive monopoly will allow them to sell the pharmaceutical drug at a very high price. Patent protection all over the world has undergone standardization after the TRIPS agreement. So, even the developing countries and the least developed countries had to introduce the product patents and grant patent rights to pharmaceutical innovations for the term period prescribed under the TRIPS agreement. This created a challenge for governments in developing and underdeveloped countries because they had to make sure that the population in those countries have access to medicine. In effect, the changes brought into the intellectual property system drastically impacted the availability of pharmaceutical products at an affordable price for the impoverished population. The traditional justification for patent protection is as follows. By granting a temporary or limited monopoly, patents enable the inventor, producer to recoup the expenses incurred in research and development as well as helps in generating profit from the manufacturing and commercialization of the innovation. This is done in exchange for the dissemination of information regarding the invention with the aim to encourage additional study and subsequent advancements. So, the underlying principle is that pharmaceutical research or the research and development of pharmaceutical drugs requires huge investment. So, if there is no market monopoly given through patent protection, the pharmaceutical companies will not be able to recoup the investment they made for the development of the drug. So, in order to make sure that drugs are available for all different types of diseases affecting the population across the world, patent system was introduced. Patents will ensure that once an innovative drug is developed, the pharmaceutical company will get a monopoly for a period of 20 years within which they can recoup the investment made for the development of the drug and can also make some profit. This will also ensure that the information or the research data about the new drug will be available to the general public as and when the complete specification of the patent application is filed. So, this will also become a ground material for future innovations and help in subsequent advancements with regard to pharmaceutical research. Hence, the patent protection can be regarded as an understanding between the society on the one side and the patent holder on the other side, founded on the notion that without patent protection there would be inadequate motivation for innovation. So, the all question before the policy makers is what kind of incentives are required in order to motivate pharmaceutical companies to develop new drugs. Additionally, this premise relies on the notion that consumers would ultimately benefit in the future as the immediate expense of paying higher prices will be counterbalanced by the emergence of novel innovations resulting from further research and development. So, even though initially the price of the drug is going to be high at least for a period of 20 years, but after the expiry of the 20 years, the new drug will fall into the public domain and thus will enable the generic industry to develop the same drug for a much cheaper price. So, even though at the initial stage the price is going to be higher, but at the later stage after the expiry of the patent, the same drug will be available for a much cheaper price. Patents thus plays a vital role in driving pharmaceutical innovation. Pharmaceutical companies have always argued that research and development in their industry involves substantial expenditure. Without patent protection, there would be little economic motivation to finance the expenses associated with exploration and creation of new drugs. Undoubtedly, patent protection has served as a crucial incentive mechanism for stimulating research and development within the pharmaceutical business. Patented medications are typically priced significantly higher than the production cost in order to generate substantial profit, even after accounting for market expenses that often exceed those of research and development. So, the underlying idea is that patented medications would be available for a much higher price compared to non-patented drugs, because creation of those drugs involved substantial expenditure which had gone into the research and development of that product. But it is interesting to note that many times companies, that is pharmaceutical companies, significantly spent for marketing expenses as well, which is many times higher than the research and development costs. In developing and least developed nations, the exorbitant cost of specific medications result in limited accessibility to treatment for people in those countries. So, when the drugs are not available at an affordable price, this will have drastic implications on the access to medicine by impoverished population. So, especially in developing countries and underdeveloped countries, the access to affordable healthcare is hindered due to patenting. Another issue pertains to the subject matter of patents. Patent applications for pharmaceuticals are not solely based on recently discovered chemical molecule or compound. There is a growing trend of submitting and frequently approving patents for different versions of a pharmaceutical product, including variations like salts or other derivatives of a molecule or other significant addition to the existing items, such as changes in form, inactive substance have been asserted and granted patent in certain nations. So, overall the grant of product patents have significant impact on the affordable pricing of drugs. There is also a problem that many times newly developed pharmaceutical products will not be solely based on new compounds or new research, but they could be substantially relying on public funded research, which is many times neglected. And on the other side, there is also a growing trend among the pharmaceutical industry to file patent applications for products which are only small variations or slight variations or even derivatives of non compounds. In India, we have section 3D which prevents such patents, but in many other countries patents are granted for these incremental innovations, which has drastic impact on the availability of drugs for general public. So, this leads us to a problem where we have to balance two competing ends. On the one side, patenting of pharmaceutical drugs is desirable because it provides economic incentives to the pharmaceutical companies to invest in research and development of new drugs. On the other side, access to affordable medicines is hindered due to the grant of patents. So, governments, especially those in developing countries and underdeveloped countries, have this challenge to find a fine balance between these two competing interests. After the introduction of TRIPS, developing countries and underdeveloped countries or the least developed countries were given a time period for implementing the provisions of the TRIPS agreement. This is commonly known as TRIPS flexibilities. The TRIPS agreement, which is part of the WTO or the World Trade Organization, mandates each government to provide certain level of protection to new innovations of other WTO members. So, this led to a scenario where there is standardization of intellectual property norms across the world. This effectively restricts the ability of governments to adopt flexible national methods with regard to intellectual property protection. So, developing countries and least developed countries were given the flexibility of adhering to the TRIPS provisions only after a specific period of time. But after the expiry of the term period, the countries which are members to the WTO will have to modify their legal systems in order to incorporate the standardized norms of intellectual property rights, which is introduced through the TRIPS agreement. So, the TRIPS agreements thus has the specific provisions for flexibilities. The objective is to allow developing and least developed countries to allow or adopt TRIPS compatible standards in a way that empowers them to pursue their own public policies. This includes aspects of access to pharmaceutical drugs, such as authority to issue compulsory licensing and allow parallel importation. Consequently, countries have the authority to implement measures that restrict exclusive patent rights if it is necessary to protect public health and provide affordable access to medicines. So, the TRIPS flexibilities, apart from allowing a time period for compliance with the TRIPS agreement, it also allowed the developing and least developed countries to adopt many legal and policy measures in order to ensure that a fine balance between the competing interest of the patentee and general public is achieved. These specific aspects included the issual of compulsory licenses. So, in cases where drugs are not available at an affordable price, or if there is non-availability of pharmaceutical products, countries have the authority to issue compulsory licenses. Similarly, they also have the authority to implement measures which restrict the exclusive rights of the patentee in order to meet the requirements of public health. So, making sure the availability of drugs at an affordable price is a challenge for developing and least developed countries. So, during the TRIPS negotiation itself, countries around the world realized this challenge. So, in order to meet these challenges, the flexibilities were included as part of the TRIPS agreement, which will give some leeway for the developing and least developed countries. Compulsory licenses are authorizations granted by the government to a third party to produce, utilize or market certain product or employ a specific procedure that has been patented. In such instances, priority is given to public interest of facilitating wider availability of patented innovation rather than the private interest of the patent holder in fully capitalizing on their exclusive rights. So, compulsory licenses which are granted by the government will allow a third party to produce or utilize the innovation without permission from the patentee. So, in case the drugs are not available at an affordable price, or if there is complete non-availability of a drug, the Patent Act authorizes the government to issue compulsory licenses. Normally, intellectual property licensing happens through voluntary licensing, but in exceptional cases, just like what we discussed now, it is possible for the government to directly issue the license. That is why it is known as a compulsory license. In order for the government to give a compulsory license, some prerequisite conditions have to be met, such as where there are compelling public interest or necessity to rectify anti-competitive behavior, the government has the authority to grant compulsory license to a third party. So, where there is a need to rectify an anti-competitive behavior from the part of the patentee, the government has the authority to issue a compulsory license. Similarly, if there is a compelling public interest, in such scenarios also, government is empowered to issue a license to the third party for manufacturing and selling the drug, which is known as compulsory license. While this is advantageous for the patent owners, disadvantages for the patent owners, compulsory licenses are only contemplated in specific instances of national emergency or health catastrophe. So, even though this is introduced to find a balance, the use of these tools are done in a very careful manner, as there is also a need to protect the incentives available to the patent owner or the pharmaceutical company, because invention of new drugs and making sure their availability is also an integral part of public health infrastructure in the country. For instances, in cases where some medications are protected by patent and priced at levels that are affordable for local population, local pharmaceutical businesses can acquire compulsory license to manufacture the generic version of the patented drug or import generic versions from overseas producers. So, when the drugs are not available at an affordable price, or if there is non-availability of drugs, local manufacturers are allowed to approach the government and acquire a compulsory license. Once the compulsory license is acquired, this will enable them to manufacture generic version of the patented drug or import the generic version from an overseas producer. Patent laws grant the government or its authorized representative the right to utilize privately owned patents for public non-commercial objectives without requiring the permission of the patentee. So, if the government wants to use an innovation, do they have to take permission from the patentee? So, in normal cases, when the government wants to use an innovation, it can get it licensed from the patentee. But in exceptional scenarios where the government wants to utilize an innovation for non-commercial objectives, then the government can utilize the specific provision provided under the Patent Act for government use and directly use the innovation without any form of permission from the patent holder. The government's authority to utilize a patent for public non-commercial purpose is defined broadly in the Patent Act 1970 and is frequently associated with procedures are far less complex. So, when there is a scenario in which the government has to use the invention without permission from the patentee, the Patent Act 1970 has adequate provisions to enable the governmental use. It enables the government to expedite the utilization of patent, which is crucial in situations where there is urgent need for life-saving medications. So, think of a scenario where there is a pandemic and there is an urgent need for life-saving medications. So, in such scenarios, getting a license from the patentee may not be feasible or may not be affordable for the government. So, in such cases, governments can utilize this provision and ensure that the drug is available to the needy at a very cheap price. The only requirement is to notify the patent holder of the intended utilization of patent. The government can utilize permits to authorize the production or importation of generic drugs specifically for their use in public hospitals. Now, let us see what is parallel import. Products protected by patents have been lawfully introduced into a market from an exporting country and then it can be imported into another country without the permission of the patent holder based on principle of exclusion of rights. So, parallel import is based on the principle of exclusion of rights. Under the principle of exclusion of rights, once the first sale is over, the first sale which is authorized by the patentee is over, the patentee cannot anymore control the resale of that particular product. So, think of a scenario where a drug which is much needed in India is highly priced here, whereas the same drug is available at a much cheaper price in a foreign country. Then in such a scenario, is it possible to buy the drug from that foreign country and then bring it to India and sell it here? According to the theory of parallel import, the right holder's authority over pharmaceutical product ends once the product is initially made available in the market. So, once the product is available in the market, then the patentee's right over that particular pharmaceutical product is over. The purpose of parallel importation is to facilitate the import of patented products from countries where they are available at a lower price due to variation in pricing across different jurisdictions. For instance, if the national legislation allows it, a patented medication can be exported from country A. In country A, it was available at a cheaper price. and then it can be bought to country B and sold here, provided this complies with the pharmaceutical regulations of country B. Developing countries have expressed strong desire in Doha Declaration to define the right to implement the international principle of exclusion of rights. Parallel imports are legally permissible, but they are done without the explicit approval of the patent holder. So, parallel imports are done without taking permission from the patent holder. Clause B of Section 107A of the Indian Patent Act addresses the issue of parallel importation. In various cases, courts have affirmed that India follows the concept of international exclusion. So, the concept of international exclusion provides that once the first sale of the drug is over in a foreign country, that product can be purchased from the foreign country and then can be brought to India and resold here. Now, let us move to exceptions to patent rights. Every country's patent laws include provisions about exceptions to the exclusive rights given by the patent. However, the specificities or intricacies of the rule differs across various jurisdictions. Exception to patent rights play a crucial role in ensuring public health by promoting transfer and spread of innovations as well as development of generic pharmaceuticals. The justification for exception to the exclusive right provided by the patents is in fact, in specific situations, it is necessary to limit the exercise of patent rights in order to serve public policy objectives such as fostering innovation, promoting education and safeguarding other public interest. The national legislation may incorporate many categories of exceptions to patent rights, with the most significant one being exceptions granted for research purpose and the early working exception. The early working exception is commonly referred to as Bolar exception. Now, let us see what is Bolar exception. Bolar exception is a legal mechanism in the patent law which facilitate entry of a generic and biosimilar product into the market. It enables the producers to produce the product prior to expiration of the original agreement. This will facilitate prompt release of the generic product once the patent has entered. So, under the Bolar exceptions, a company is used to access the research data and do the necessary modifications and make the drug ready for marketing once it is approved by the drug controller and the patentee's patent has been expired. So, now let us see what is the rationale behind Bolar exceptions. So, once the patent monopoly is expired, a competitor is free to introduce the same drug in the market. That is because once the patent monopoly expired, the drug will fall into public domain, so that anybody can manufacture and sell it. But if a company wants to produce a generic drug which has fallen into public domain, they need to get some approvals from the Drug Controller of India and also has to comply with some regulatory standards. In order to comply with the regulatory standards, they need to produce some samples and also do some testing. While doing this, the company may be infringing the patent rights, but Bolar exceptions will allow such generic manufacturers to do the testing, seek and get the regulatory approval, so that the pharmaceutical product will be ready for marketing as soon as the patent is expired. The competitor's ability to commence work to fulfill the regulatory requirements and bring their product to the market after expiration of the original patent will be normally hindered by the patent. But Bolar exceptions will allow the companies to do this work and complete it before the expiry of the patent term. If there was no Bolar exceptions, the companies would not have been able to experiment the drug, gather the required information for regulatory approval and get the manufacturing done before the patent expires. So, Bolar exceptions in effect ensures that the patent terms are not extended beyond the period stipulated in the statute. Now, let us see the TRIPS flexibilities available for India. India prioritized on safeguarding public health during the negotiation of the TRIPS agreement. The Patent Act of 1970 did not include provisions for granting of product patents, specifically for inventions related to pharmaceuticals. The protection period for process patents was restricted to a maximum period of 7 years. The deliberate decision made in the India's Patent Act favored the generic industry in India. Because of this, the generic industry thrived in India. But after the acceptance of the TRIPS agreement, India had to change the rules and make product patents also available for the pharmaceutical companies. India subsequently took deliberate attempts to integrate various flexibilities under the agreement and the Doha Declaration into the Patent Act through the amendments made in 1999, 2002 and finally in 2005. Thus, India strategically utilized the flexibility provided in Article 65 of the TRIPS agreement to postpone the application of product patent protection for pharmaceutical innovations till 2005 as part of utilizing the TRIPS flexibility. The distinguishing character of Indian Patent Act is the deliberate effort to precisely define the types of subject matters which are qualifying for patent protection under section 3 of the 1970 legislation. Although the Act provides detailed explanations for the three fundamental criteria of patentability, which is novelty, inventive step and capable of industrial application, section 3 explicitly includes provisions to prevent some innovations from being eligible for patent protection, and some of such measures are specifically applicable for pharmaceutical related innovations. To conclude, the TRIPS agreement grants the WTO member countries the ability to implement varying legislative policies in some areas with the aim to achieve greater consistency in country laws and practices concerning intellectual property rights. These flexibilities can be utilized specifically to implement policies that promote competition and encourage the spread of innovations, particularly to ensure the availability of pharmaceutical innovations. The references of this lecture can be seen here. Thank you very much for listening to this lecture. I hope you are enjoying the course.